Good afternoon, attending attorneys, professors, and judges. It is a pleasure to present this expert testimony on behalf of the New Zealand Digital Forensic Team regarding the cyber incidents at the Five Eyes Summit. As you may know, digital forensics is becoming a growing necessity currently with the growth of technology. Nations, organizations, and individuals are seeing an increase in cyber attacks constantly. Digital forensic investigators handle the recovery and investigation of evidence that is legally found on computer hard drives, mobile devices, digital storage files, or software. The investigators are responsible for preserving, collecting, validating, identifying, analyzing, interpreting, documenting, and presenting digital evidence. Digital forensic investigations can also be an essential resource for nations, organizations, and individuals that face data breaches or other cybercrimes. Having the ability to examine computer hard drives, digital storage files, and software helps authorities in identifying the source of attacks. The New Zealand Digital Forensic Team handled several investigations at the Five Eyes Summit, which included a security baseline, defensive monitoring, Wireshark packet capture analysis, and a ransomware attack and mitigation investigation. These investigations require the New Zealand Digital Forensic investigators to use several tools to identify and uncover sources of attack. The tools used for the investigations included Nessus, OpenSCAP, Yara, Thunderbird, Wireshark, Snort, CryptTool, Excel, OPHCrack, Our Secret, Kane Enable, Toolkit, and FTK Imager. The court has been provided with a compilation report detailing the Five Eyes Summit investigations completed by the New Zealand Digital Forensic investigators. I look forward to answering any questions the panel may have. The first question posed to the New Zealand digital forensic expert by the panel is, what are the legal challenges associated with cyber incidents involving foreign countries? How do internal laws affect e-discovery? Reference and discuss all international laws that may influence a forensic investigation in the country that your team is assigned. The legal challenges associated with cyber incidents involving foreign countries are the differences in laws between each country. Laws are regionally aligned with the territories of countries they originated from. Every country has its own set of laws and regulations that must be followed. Data protection laws are governed by regions within a country, meaning that a legal process conducted in one country could be illegal in another. Internal laws can impact data retrieval techniques, data storage methods, and data analysis procedures for e-discovery. Each process must be followed according to the laws of the area, otherwise there is a risk of illegally handling private digital areas. Criminals take advantage of differing laws between countries by launching attacks from countries where the laws aren't as strict, or launching attacks from rival countries. External laws are not enforceable in New Zealand unless an agreement or treaty is sanctioned. Laws that may influence forensic investigation in New Zealand include the Privacy Act of 1993, the Intelligence and Security Act of 2017, and the General Data Protection Regulation, also known as GDPR. The Privacy Act of 1993 governs how agencies collect, use, disclose, store, retain, and give access to personal information. The Act gives the Privacy Commissioner the power to issue codes practice that modify the operation of Act in relation to a specific industry, agencies, activities, or type of personal information. The Intelligence and Security Act of 2017 is in place to protect New Zealand as a free, open, democratic society by establishing intelligence and security agencies that will effectively contribute to the protection of New Zealand national security, international relations, and well-being of New Zealand, as well as the economic well-being of New Zealand. Additionally, the Act strives to give intelligence and security agencies adequate and appropriate functions, powers, and duties. The General Data Protection Regulation (GDPR) imposes a uniform data security law on all European Union members, so that each member state no longer needs to write its own data protection laws, and laws are consistent across the entire EU. In addition to EU members, it is important to note that any company that markets goods or services to EU residents, regardless of its location, is subject to regulation. As a result, GDPR will have an impact on data protection requirements globally. The next question posed to the New Zealand digital forensic expert by the panel is, what are the legal challenges of accessing and retrieving electronic evidence stored on foreign soil? Assuming cloud storage was used, what procedures were followed to access and retrieve digital evidence stored in the cloud? Laws in other countries greatly impact how electronic evidence can be accessed and retrieved on foreign soil. It is important to remember when retrieving digital evidence stored on foreign soil that the laws must be followed where the data is stored, not the laws of the party accessing or retrieving the data. If the laws are not abided by, parties can be prohibited from collecting or gathering electronic evidence. This is why it's important to understand the policy differences between each country. Ensuring emphasis is placed on reviewing foreign country policies before attempting data retrieval is important. If evidence is stored in the cloud, there are generally specific security requirements set by the original owner. These requirements must be met by the digital forensic investigator. Cloud storage devices and platforms can be regulated by contractual guidelines requiring both sets of parties to adhere to the previous established set of rules. Cloud data presents a challenge for digital forensic investigators as it is seen as residing in virtual space, not a physical location. However, it goes back to the jurisdiction of the original owner. All New Zealand organizations are subject to New Zealand's legislation by default. The New Zealand Privacy Act of 1993 is a legislation that addresses both providing and using cloud services in New Zealand, followed by the Public Records Act, the Tax Act, and the Customs and Excise Act. A common point of these three acts are they all limit the storage of specific types of data, offshore or in the cloud. The main point of such limitation is to protect the information owner's rights to or to protect certain sensitive information. Through the NZ Cloud Computing Code of Practice, professional and responsible cloud service providers benchmark and demonstrate their practices, processes, and ethics via an independent third party to build trust with prospective customers. When accessing and retrieving digital evidence stored in the cloud, parties must remain in compliance with all relevant legislation, such as the Privacy Act of 1993, Public Records Act of 2005, and the Health Information Privacy Code of 2008. The next question posed to the New Zealand digital forensic expert by the panel was specific to the country that your team was assigned. How did the international laws and jurisdictions influence the process and procedures followed during the forensic investigation? A prevailing theme between countries when it comes to digital forensic investigation is the use of chain of custody forms and maintaining data integrity, which is done by using forensic images or hashing. However, international laws and jurisdictions make the forensic investigation process longer by the different laws and procedures that investigators are required to follow when handling data. For instance, New Zealand digital forensic investigators had to familiarize themselves with the United States laws regarding data retrieval and handling before proceeding with its investigation of the DOS and ransom attack at the Five Eyes Summit. The investigators had to make sure the information collected remained in its original state and that every step taken was documented. If New Zealand did not abide by the United States guidelines, they would have been prohibited from accessing the data, which would have greatly impacted their DOS and ransomware attack investigations. The next question posed to the New Zealand digital forensic expert by the panel is what conflicts arose between ethics and international laws during the forensic investigations? How did these conflicts affect the investigations? How were the conflicts mitigated or resolved? New Zealand did not have conflicts between ethics and international laws during its forensic investigations. However, with digital evidence collection, there could be an incident that requires private data to be accessed. This is where a conflict between ethics and international laws can arise within a forensic investigation. Some forensic investigations have required the viewing of emails, text messages, documents, and written communication, all of which can be classified as private data. The rules and regulations that digital forensic investigators must follow protects both the privacy of users and the intentions of the investigator. Digital forensic investigators can only access or collect data that pertains to a case in which legal permission has been granted to access or collect that data. International laws within the investigation did not impede on the forensic investigation as procedures were adjusted to fall within the regulations of the country in which the investigation was taking place. The last question posed to the New Zealand digital forensic expert by the panel was what steps were taken to protect New Zealand soil and citizens during the international investigation? Describe any risk to the country, businesses, or citizens from your investigations. To protect the soil and citizens of New Zealand as well as the United States during the international investigation, New Zealand's cyber management team hardened the network infrastructure. This was accomplished by deploying intrusion detection systems and intrusion prevention systems as well as antivirus software. In doing so, New Zealand hoped to prevent future malware or ransomware incidents from occurring. There were also stringent encryption protocols, digital certificates, and authenticating services implemented to ensure that the data being sent and received maintained its integrity. New Zealand deployed the DOS prevention tools Cloudflare and Arbor DDoS to stop DOS attacks before they could occur. The cyber management team also implemented the network monitoring and analysis tools Wireshark and CloudShark. New Zealand provided nations that were a part of the Five Eyes Summit training guidelines to recognize phishing attacks, which can lead to the execution of malware attacks. New Zealand believes the security precautions taken will protect its systems as well as the United States from cyber attacks. Countries, businesses, and citizens face the risk of losing important private information as well as possible financial ruin. While individuals fear having their identity stolen, the countries fear having national security information stolen. The security of private information falls on the shoulder of the government agencies established to combat cyber terrorism, as well as legislation passed addressing electronic data storage and private data access. This concludes the expert testimony for New Zealand in this court hearing. Thank you to all attending parties.